A man sits in his prison cell, sentenced to 25 years for a crime he insists was unfairly punished. His last hope? An appeal. But in the federal system, winning an appeal isn't easy. Will the court correct the sentence, or will justice remain out of reach? The appeals process is the next step, a final chance to challenge the sentence and seek a different outcome. But how does the federal sentencing appeals process actually work, and what does it take for an appeal to succeed? Unlike trials, which focus on determining guilt or innocence, appeals are not about re-arguing the case. Instead, they focus on whether the law was applied correctly during sentencing. Defendants cannot appeal just because they don't like the sentence. They must prove that a legal error occurred. This could include misinterpretation of the law, incorrect application of sentencing guidelines, or constitutional violations. It's important to note that sentencing appeals differ from appeals challenging a conviction. A defendant may accept guilt but still argue that the sentence was unfairly severe. This distinction is crucial because while conviction appeals require proving innocence, sentencing appeals focus solely on whether the punishment fits within legal guidelines. The federal sentencing appeal process begins with filing a notice of appeal. This must be done within a strict deadline, usually 14 days after sentencing. The appeal is reviewed by a federal appellate court, which does not conduct a new trial, but instead examines the record of the original case to determine if errors were made. One common ground for appeal is procedural errors. If the judge miscalculated sentencing guidelines, applied an incorrect enhancement, or failed to consider mitigating factors, the sentence could be overturned or modified. Another reason for appeal is constitutional violations, such as a defendant being sentenced based on biased information or without proper legal representation. The process involves filing a written legal brief, in which the defendant's attorney argues why the sentence should be overturned. The prosecution responds with its own arguments defending the sentence. In some cases, the appellate court may hold oral arguments where both sides present their case before a panel of judges. After reviewing the case, the appellate court has several options. It can uphold the sentence, meaning no changes will be made. It can vacate the sentence, requiring a new sentencing hearing, or in rare cases, it may reduce the sentence if it finds a significant error in the original judgment. Winning a federal sentencing appeal is difficult. Courts give trial judges broad discretion in sentencing, and appeals are only successful if clear legal errors can be demonstrated. However, when an appeal is granted, it can result in a lower sentence, a new sentencing hearing, or even a complete reversal of the sentence. One notable case where a sentencing appeal changed the outcome involved the Fair Sentencing Act of 2010, which reduced sentencing disparities between crack and powder cocaine offenses. Defendants sentenced under outdated guidelines were able to appeal and receive reduced sentences. This shows how legal changes can sometimes provide opportunities for sentencing appeals even after conviction. Another example is the case of Victor Rita, a military veteran sentenced to 33 months in prison for perjury in 2005. Rita appealed, arguing that his sentence was excessive given his service and personal history. The case reached the Supreme Court, where the sentence was upheld, reinforcing the wide discretion that judges have in federal sentencing. Federal sentencing appeals are complex and highly technical, requiring strong legal arguments and a clear demonstration of judicial error. While not every appeal results in a reduced sentence, the process serves as an important check on judicial power, ensuring that sentencing follows the law. Should sentencing appeals be more accessible to correct potential injustices, or do they already serve their purpose by protecting judicial discretion? If you were the judge, would you grant more appeals or uphold more sentences? Like and subscribe to 0 Hour Files for more in-depth legal insights and courtroom analysis. As Mats Fredriksson wisely says, justice isn't just about punishment, it's about making sure the law is applied fairly.